factor number 16 is any other relevant factor. So the judge writes, father's credibility. Although father presents himself as the one who is telling the truth and mother and others are not, the court finds him not credible. As indicated in factor 15, he presents himself as someone who is in fear of his safety when he is the one with a history of violent conduct. Whenever he was presented with the fact that appeared to work against him, he became evasive. There are many examples, such as when he was confronted with the fact that he allowed the child to go back to mother smelling and responded by saying he was teaching the child to do things for herself. Troubling statement by father. Father admitted that he took the photo of the child playing the violin with no shirt on where her chest was fully exposed. His defense was that he looks at her and sees a big baby in a diaper. B. Father admitted that he slept with the child with her shirt off and sent mother a photo which concerned mother where the child was in bed with her shirt off. It is unclear as to whether father had slept in the same bed with the child. Mother requested that father not allow the child to sleep with her shirt off. He testified that he took his daughter, the subject child, for a couples massage multiple times. Father allowed child to be without a bra on multiple occasions, which concerned mother as she sent the child to father wearing a bra. Testified that once the child came back from a visit with mother, the child smelled like a woman's vagina all over her body, not just in one part of her. She writes all of this in her May 3rd opinion. And now in her response to my appeal to the Superior Court, she pretty much cites some of the same reasons. The following facts have given the court troubling concern for the safety of the child. Father allowing the child to be around him while she is naked and wears no clothes. And none of this stuff is current. This is all stuff when she was a baby that they're making it seem like it was current. Father taking a photo of the child playing violin while she was naked and sleeping in the same bed with him while she was naked. Okay, you see right here, sleeping in the same bed. Up here, she says the same thing, but says it is unclear as to whether father had slept in the same bed with the child. So father referred to his taking the child for couples massage where both he and the child are together in their underwear. Father's unusual statements regarding the child returning to him with the smell of a woman's vagina all over her body. The recollection of the exact day the child had her first menstrual cycle. A video of the child pointing to the father when asked about who did patty cake chin. So she mentions this twice. This is also in her May 6th order, number 6. We're gonna do a whole episode on that one. A video of the child pointing to the father when asked who did patty cake chin. Remaining part of her response to my appeal, she says the court is acutely aware of the implications of the finding of sexual abuse, but equally concerning is the child's inability to verbalize what occurs when she is alone with father. The trial court has given father much leeway in the presentation of his evidence and the ability to cross-examine witnesses. The court has been fair and impartial towards father, despite his ridicule and disrespect towards the court. Father has alleged in his statement of errors complained of matters which allegedly have occurred after the order of May 3rd, 2024. It is respectfully submitted that these should not be considered by the Superior Court. In conclusion, although father's concise statement is voluminous, father disregards the finding of this court as they do not fit his false narrative. He argues everything else but the facts as he constructs his diversion. He did not address the disturbing testimony and behaviors that are his and his alone. The court pondered and labored over its opinion in order of May 3rd, 2024. The issue on appeal served only to distract and deflect from the real issue of best interest, child safety, and child welfare. It is requested that the May 3rd order should be affirmed. So once I did my brief, I challenged all of these false narratives that the trial court was trying to create. And this was the first one. Father allowing child to be around him while she is naked and wears no clothes. I'm not going to read through all of this, but this is pretty much, I've cited this throughout the episodes that they're bringing up stuff that from when my daughter was a baby and making it seem like it's current. So number 5, I said the child currently has a cognitive level of a much younger child due to her autism, which is an important factor to consider when evaluating her behavior and needs. It's concerning that the court appears to be mischaracterizing evidence from the child's early childhood and potentially considering the context of her autism and associated sensory issues. Autism can significantly impact a child's sensory processing and behavior, including sensory to clothing. The court should consider ensuring that any statements made about the child's care are supported by current factual evidence rather than hearsay or misinterpretations of past behaviors. And that's pretty much what it comes down to. My daughter, when she was younger, she didn't like wearing any clothes, so she would walk around in her diaper, or I mean, just like most babies. But maybe her phase of doing that lasted maybe a year or two longer. So when she was around 6, that's when it stopped. Okay, so father taking a photo of the child playing the violin while she was naked and sleeping in the same bed with him while she was naked. I said to the Superior Court, the trial court is attempting to classify a Bain incident as a case of child pornography, alleging that a father took a photograph of his daughter playing the violin while she was unclothed. The daughter, who is now 11 years old and diagnosed with autism, had, during her early childhood, awakened one morning and began playing the violin in her own bed. The father, having encouraged her musical interest, found the moment endearing and captured it in a photograph. At the time, the child was wearing only underwear and the violin obscured her chest area. The photograph was sent solely to the child's mother with the intention of sharing a joyful moment. It was neither disseminated online nor sold to individuals with inappropriate interests in images of minors. This situation underscores concerns regarding the trial court's interpretations of actions and the concepts of child welfare as it attempts to attribute criminal intent to an innocent father. Second one, father referred to his taking the child for couples massage where both he and the child together in their underwear. The court's implication that the massage therapy sessions involving my daughter constitute some form of abuse is both unfounded and legally questionable. Parental rights includes the right to choose appropriate therapeutic treatment for their children, especially such treatments are beneficial and conducted by a licensed professional. There is no indication of harm or impropriety in described therapy sessions. The presence of a licensed massage therapist adheres to facility policies, and the long-standing history of these sessions benefiting my daughter's condition further support the legitimacy of the therapy. Massage therapy is a recognized treatment for children with autism. In conclusion, the court's characterization of the massage therapy sessions as inappropriate is disturbing and legally unsound. Father's unusual statement regarding a child returning to him with the smell of a woman's vagina all over her body. In the ongoing legal proceeding, the court appears to be misinterpreting the father's statements and attempting to cast him as an alleged abuser. The father reported an unusual odor on his nonverbal autistic daughter upon her return from the babysitter, which he described as reminiscent of a woman's intimate area. At the time, he was unaware of its implications and considered various innocent explanations. The court seems to be overlooking evidence that implicated the babysitter in an inappropriate behavior, which led to a court order prohibiting unsupervised contact between the babysitter and the child. Instead, the court appears to be focusing on the father's initial observations, framing them as unusual statements and potentially using them to insinuate misconduct on his part. This approach by the courts raises concerns about potential gender bias in family court proceedings where mothers' allegations against fathers may be given more credence even in the absence of substantiative evidence. The court's appearance attempt to reframe the father's concerns as potential indicators of his own misconduct rather than a legitimate observation that led to the discovery of abuse by another party suggests a troubling pattern in how such cases are handled. The situation highlights the challenges faced by parents, particularly fathers, in navigating the legal system when dealing with complex issues of child protection and custody. It underscores the importance of careful consideration of all evidence and the potential for misrepresentation or bias in legal proceedings involving allegations of child abuse. Misrepresentation, particularly fraudulent misrepresentation, involves making a false statement knowingly, recklessly, or without belief in its truth, which induces some to act to their detriment. In this case, if the court is knowingly or recklessly misrepresenting the father's statements to cast suspicion on him, it could be seen as a form of judicial misrepresentation. Historically, Congress has taken action to correct judicial misrepresentation of statutes as seen with the Civil Rights Act of 1991, which overturned several Supreme Court decisions that misrepresented federal anti-discrimination laws. This precedent suggests that legislative bodies can and do intervene when courts misinterpret laws or evidence in ways that undermine justice.